ready, Judge?
Yeah, I'm had to get it on the line. Okay, we're in session in cause number 330376. The case is style of state of Texas versus Jamal Anthony Joseph. We have Mr. Jamal Anthony Joseph appearing via Zoom. Mr. Joseph, is that your full name?
Yes, sir. Correct.
How you doing, Mr. Joseph?
All right. How you doing, Mr. Holmes?
I'm doing fine. Now, Mr. Joseph, you're represented here in your case by your attorney, Mr. Langston Adams. Mr. Adams, how are you doing?
I'm doing well.
That's good. Now, Mr. Joseph, on December 16th of 2021, you were sworn in, you entered a plea of no contest to the charge of assault, family violence, which is a Class A misdemeanor, and you had, I have documents before me. First document that I have is a misdemeanor plea admonishment, and on this document, you acknowledge that those were your initials on page 2 of this document on a line that is checked nola contendere, which means no contest, and you also have initials, both your initials are JJ on above a paragraph that was written in by the court that said it was a waiver of record, which says comes now the defendant adjourned by my counsel and states that I understand that I have a right to have a record in this case, but I give up my right to have a court reporter to record to record in this case. And also, I have on page 3 of this document, there's a signature that you acknowledge that was yours above the line that is titled defendant. And I have another document here that states trial court certification of the defendant's right of appeal. At the bottom of this document, you acknowledge that that was your signature above the line is titled defendant. One box is checked saying that this is not a plea bargain case and the defendant has a right of appeal. Now, let me do this here. Mr. Joseph, would you please raise your right hand? Mr. Joseph, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Now, Mr. Joseph, was that correct in what I said in reference to you acknowledge that that was your signatures on the misdemeanor plea admonishment, which is State's Exhibit 1, and your initials on that document?
Yes, sir. Correct.
And that your signature was on trial court certification of defendant's right of appeal, and also, did we have a, I don't see, Mr. Adams, did y'all do a discovery certification? I don't see that in the file. Let me see that.
It should be in there.
Okay.
We did that on the same day we did the plea paperwork.
Yeah.
What's the case number? Just give me the case number, I can look it up.
The case number is 330376.
This one in here, I'll put
It is? Okay. It just, they have to print it, okay. All right. Now, Mr. Joseph, I also have a document here that is titled Discovery Certification. And I think back on December 16th of 2021, when you entered your plea of no contest, you also acknowledged that that was your signature on this document as well. Is that correct?
Yes, sir. Correct.
And you also acknowledge that your attorney went over these documents with you and that you read and understood everything that he went over. And
Yes, sir.
everything in these documents is true and correct to the best of your knowledge. Is that correct?
Yes, sir, correct.
All right, all right. Now, the court previously, I think we'll just do it for the record again, but I think that we previously, Mr. X, your attorney, Mr. Adams, you advised and counseled Mr. Joseph. Is that correct?
Correct.
Mr. Adams? Your mic is on mute.
Yes.
And is there any evidence that he was mentally incompetent to stand trial?
None, zero.
And Mr. Joseph, your attorney, Mr. Adams, has advised and counseled you. Are you satisfied with his representation?
Come again?
Mr. Adams has advised and counseled you. Are you
Yes, sir.
satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Okay. Now, Mr. Joseph, the court is going to accept your plea of no contest. The court is going to find that you're mentally competent to stand trial. The court is also going to find that your pleas and waivers was freely voluntarily given. And the court is going to find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a punishment recommendation?
Yes, I do.
Oh, hold on. Let me do this here. Now, Mr. Adams, I have before me a document that is titled a pre-sentence investigation. Mr. Adams, did you receive a copy of the pre-sentence investigation?
Yeah, I have it in with me right now.
Okay. And Mr. Boyd, you're the Assistant District Attorney for the DA's office. Did you receive a copy of the pre-sentence investigation?
Yes, Your Honor.
Okay. Now, let's see. Now, Mr. Adams, would you like to make any, before you make, I just asked the question, yes, no. Would you like to make a comment regarding the pre-sentence investigation?
Just argument as to what your sentence should be.
Okay, and the reason why I was asking, the reason why I was asking, because if you was gonna, the pre-sentence investigation is considered confidential. And so if anybody wanted to make any comments about the pre-sentence investigation, I would have informed them that all proceedings and trials in court shall be public. However, pursuant to Lilly versus State 365, Southwest 3rd, 321, the right to a public trial is not absolute and may be outweighed by other competing rights or interests, such as interest in security, preventing disclosure of non-public information, or ensuring that a defendant receives a fair trial. And so,
if you're asking, take it off of Zoom so we can comment on the free PSI. Yeah, that's fine. Take it off of Zoom. I'm not off of Zoom Live. That's what I meant to say. Zoom Live.
Right. Okay.
I'm for that. Yes.
Okay. So the court finds that the party seeking to close the hearing have advanced an overriding interest that is likely to be prejudiced. That is, it would involve the disclosure of non-public information. And two, the closure is no broader than necessary to protect the interests of the defendant. And the court have considered reasonable alternatives to closing the proceeding. And the court makes the findings that the court makes are adequate to support the closure. So at this time, this hearing will be closed to